This is Brad Hall.
Was tightening and stuff. He thought it was right.
Right.
So I met that something. And we helped fix it. It actually was it was longer to get there than getting the stuff done, so.
This will be fun.
Hey, happy Wednesday.
Happy Wednesday.
So watch your step going over that way so you don't trip over that cord. Do not need any workman's comp case.
And don't forget, there's the speaker there.
Oh my
the
gosh.
Microphone over there.
You're being tapped.
Guys can sit there.
You guys can have this.
Freeway.
This.
We have to. I don't need anything. They don't need me to say anything. You know how I roll.
I don't want this. It's cool.
I did not want to step on your nose, but I just know that I didn't step all over.
Oh, and
I'm Patty. I know you're the Michael.
Yeah, I'm Michael.
And we met in passing in the other one. So I used to be in code with Dan for years, but, so if you guys ever have any questions, I'm happy to help. I'm on this side now. I'm with legislation and host council now. You pulled me over.
Nice to meet you.
I said what?
met last time, but we've not been introduced.
Oh.
Michael, we met last time, so welcome.
Gave you your meeting. What's your document number, sir? 123. Just ask. All right, let me. Love mine. So. When I went to look at these codes. So I had to post these codes and I went to public. We don't have no access. So maybe this was, this was it. The first time I pulled it up, I went to like the city's website and the council's website. It only gave me the charter in a really weird format. This is what I was looking for. I Googled Cleveland codified ordinances and I got the link. It came up as code library. I'm like, okay, that didn't come up the first time. I'm happy to share. You know, because what's beautiful about this is you can do this. I love this. Yeah. So, and then I have my email. I can with connection to my phone, like, you know what I mean? But right now, like, I'm on the city's Wi-Fi. Oh, yeah, I brought that. I was like, okay, I've got to absorb it. I read through it and I didn't absorb it. But I think it means that I need to add some language, but I think my last is push back. So we'll have to see where we end up. You know what I mean? But I did bring this to try to reread. Oh, look at that. So I thought it was a straw at first. Oh, I gotcha.
Morning. Can
Is
you
that
hear me?
Mr. Mansky?
This is Vanover.
Oh, yes, we can hear you, Tom.
Right. There's no echo or feedback?
No, it's pretty clear.
Awesome. Thank you.
No, he just gave me this. What I did was I printed this out and left it on his chair with a note that said, hey, Jeff, I emailed this to you Thursday. Would you mind reviewing and giving me comments? Yeah, I gave, this was the thing, and then this is how it reads now. So. Yeah, no, because I do think I agree with Jeff on that, because it does say, where is it? It's, arising out of connected to the extent caused by the negligent act consultants in their performance, so it's to the extent of their performance, of their acts. So I think I do agree with Jeff that I think that language covers that. And proportionate share is joint several liabilities is under the codes anyway. Because it's also one of those things where you can contract extra. They're not willing to contract extra, right? So, because you can leave it. There's also a change
Okay, Ms. Davis,
to that code, it's to you. She stepped out, I'll grab her.
okay,
She will listen to this.
Okay, she goes back to the office.
Do the council, where's the council?
That's, I was looking,
Oh, that's not.
I didn't see him.
Oh, it's not out here.
You take the lock off, Patty? Okay, thank you.
Maybe where we can call them.
Oh, there you go, okay. Okay, Mr. Chairman, you can start with the preamble.
okay, in compliance with notification requirements of Ohio's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with the participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. All call-in users can unmute by using *6. All meeting activity is being recorded by way of the WebEx platform. these proceedings are also being live streamed by way of YouTube. All requests to speak in a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comment on a particular matter. Mr. Jacobson.
Mr. Chairman, this is Dan Jacobson from the Law Department. As a preliminary matter, can we verify that the live stream is on and functioning?
Yes, sir.
And Mr. Chairman, as the Law Department has done since these meetings have gone virtual and or hybrid, law objects to the use of the chat function. Thank you.
Okay. Let's see, call the roll.
Mr. Bradley,
Here.
Mr. Maschke,
Here.
Mr. Gallagher.
Here. We have 3 board members, and when we only have 3 board members, which means that if our decision is not unanimous, which it usually is, then your appeal goes back to the city. If for that reason you prefer not to have your case heard, then let me know when we call your case that you would like to reschedule your case. Okay, the Board of Building Standards and Appeals is now in session. Do we have Councilman Conwell on?
He's not back in the room 514.
Okay, so we're gonna move the dockets around a little bit here, but docket A7823 has been withdrawn. So we are going to move to docket A7723. Okay, so A7.
Application and fees are in order. Notice of violation is interior and exterior maintenance issued on March 28th of 2023. Appeal statement was received on April 14th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson, Department of Law. Will the appellant or his or her attorney or representative please state your name for the record? Mr. Chairman, I
Yes,
do not see Doris Oregon in the participant panel this morning.
okay. We'll swear in Mr. Vanover. Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Mr. Chairman, to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, anything physically delivered to you on behalf of this appellant and or docket?
To the chairman, to Mr. Jacobson, no.
And to the chairman, the due process requirement of notice have been given. The board can proceed with its hearing and its ruling. Thanks.
Okay, very good. Mr. Vanover.
Mr. Chairman, it appears that the open violations on the
Yeah,
Tom, we're having,
Tom, you broke up.
you there?
Yes, is this Mr. Vanover?
Yeah, sorry, I don't know what happened there.
Okay,
So the violation record shows that it's in compliance, so we ask that you deny, or that you just remand it back to us. There's
Okay.
no,
You don't want like a today's date on it?
I didn't, I mean, that's theirs to ask for and they didn't bother to show up, so.
Okay, so we'll remand it. I got you. Okay. So a motion is in order to deny more time and remand the property to the Division of Building and Housing for any further action.
So moved.
Okay, moved by Mr. Maskey,
Second.
second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Maschke,
Yes.
Mr. Gallagher.
Yes. Okay, a notice will be sent out to him within 2 weeks. Next docket is A 7923, 4278 East 119th Street.
Application and fees are in order. Notice of violation is interior and exterior maintenance. Issued on March 6th of 2023. Appeal was received March 17th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Department of Law. Will the appellant or his or her attorney or representative please state your name for the record? Mr. Chairman, I do not see a Mac Warren in the participant panel.
Okay, Mr. Vanover, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Mr. Chairman, to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Mr. Chairman, to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given, the board can proceed with its hearing and ruling today. Thank you.
Okay, thank you. Mr. Vanover.
So, Mr. Chairman, this is a rental property that was called as part of our rental registration or rental inspection program. It was, and it's an interior exterior maintenance notice of an investment property. So we had to deny any more time and remand it back to the department.
Motion is in order to deny more time and remand the property to the Division of Building and Housing for any further action.
So moved.
Moved by Mr. Bradley,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maschke,
Yes.
Mr. Gallagher.
Yes. Notice will be sent out within 2 weeks. Docket A 8023, 3115 West 58th Street.
Application and fees are in order. Notice of violation is no permit. Issued on February 17th of 2023. Appeal was received on March 14th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name for the record?
Alessandro Cacciola Jr.
Okay, we maybe come back again with your name.
Alessandro Cacciola Jr.
Okay. Mr. Cacciello, are you the owner or attorney?
I'm the owner.
Okay, very good. Let us know what your plans are.
Moving forward with the repairs, they're just taking a while because your housing code specialist or inspector, I think, listed like 45 particularly little things and big things. So some of the bigger things are taking time, but we've cut the grass. We've removed the debris from the back of the property. We've removed the debris from the stairwell. We've painted the inside of the unit. We've had a licensed exterminator come through and treat for, even though they're not there anymore, we've had them treat for mice and for other insects. We partially painted the porch. So we are working towards it. It's just taking time.
I'm noticing in some of the pictures, there is some deterioration of the roof of the porch.
That was on the original code list or the violation list. So that's another thing we're working on as well.
Okay. All right. How much more time do you think you need?
I'd say another 45 days. The biggest problem is the roof because to do it the right way probably means it has to be replaced. And the quotes we've been getting for roofs are between 12 and 15,000. And we're in the process of selling a couple of other properties to raise money to do the roof. So I would typically have said 30 days, but with the delay to sell the properties and get those closed, I'd say 45 days.
Okay, thank you. Mr. Vanover.
So, Mr. Chairman, this unit is currently unoccupied. It's currently vacant.
The upstairs unit is. The downstairs unit has had a long-term tenant in it.
Okay, because again, based on the photographs, there's a lot of deterioration upstairs. Mr. Chairman, we don't object to more time, but we providing that it stays vacant and no further extensions of time. It's not contingent on whether you sell your other properties or not. There's an expectation that your rental properties are maintained.
Well, unfortunately, if I don't have $15,000, I can't tell a roofer do a roof. So I'm doing
Mr.
the best
Chairman,
I can.
we ask that you deny any more time and remand it back to the Department of Building and Housing for further action. Because it doesn't look like that the owner can afford to maintain the properties they own.
No, that's clearly
ask,
not what I said, and you're misstating my words. That is not what I'm saying. What
So,
I'm
Mr.
saying
Chairman,
is that I will have the funds.
Okay.
Mr. Chairman, we ask that you deny any more time and remand it back to the Department of Building and
Clearly
Housing.
favoritism. He's has an attitude now because I clarified my words. So this is definitely retaliatory.
Mr. Chairman, if I may,
being recorded.
If the meeting is recorded, sir. If I may, and perhaps I misunderstood, but I believe that the appellate just said that if he didn't sell the properties and doesn't have the money, then he cannot tell the roofer to do the work. Is that accurate?
No, that would mean I would have to find other sources that would involve me taking on long-term debt. So please, once again, do not try and coerce my words or change my words. I have made progress on the repairs. Nobody is complaining of any damages at the property. The one tenant that is there is living a perfectly fine life, and we are addressing the issues. And even then, if I got 95% of the other things done, I said to do the roof the right way. I could easily stick to code, put flat roof on it, and do it the cheap and shoddy way. But I'm trying to do it the right way. So please, again, I don't need the implication of changing my words around.
All right. I've heard, and I think to Mr. Vanover's point is that, when you're in a business when you're renting these properties, so they expected them to be, kept up, and they shouldn't even have to cite you. Okay. So having said that,
so just to be clear, would you guys rather I put flat roof on there as per code and do it the cheap way?
Nobody's saying that. Okay.
That's what the other Mr. Vanover is. I'm not you, sir, but Mr. Vanover seems to want me to do it that way, and I'm happy to do it the cheap way and just satisfy everybody. But I'm trying to do things the right way, which is why I said I would like more time to get the money to do it the right way. And if I can't, then I'll do it the cheap way and still keep everybody happy.
Okay, so I'm gonna recommend that we give you 45 days. That'd be November 11th, 2023 to abate. Mr. Bradley, second by Mr. Maschke.
Thank you.
Mr.
Have a good day.
Bradley,
Yes.
Mr. Maschke,
Yes.
Mr. Gallagher.
Yes. Okay, the notice will be sent within 2 weeks. Is 8123 13911 Castelia Avenue.
Application and fees are in order. Notice of violation is interior and exterior maintenance issued on April 14th of 2023. Appeal was received April 17th, 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name for the record? Mr. Chairman, I do not see a Monique Hall in the participants panel.
Okay, Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Mr. Jacobson?
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
To Mr. Chairman, to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, anything physically delivered to you on behalf of this appellant and or docket?
To Mr. Chairman, to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given, the board can proceed with its hearing and ruling. Thank you.
Thank you. Mr. Vanover?
Mr. Chairman, this is again a rental property. It's an investment property. And we ask that you deny any more time and remand it back to the Department of Building and Housing.
Motion is in order to deny more time and remand the property to the Division of Building and Housing for any further action. Motion by Mr. Bradley, second by Mr. Maskey.
Mr. Bradley? Mr. Maskey?
Yes.
Mr. Gallagher?
Yes. Notice will be sent out within 2 weeks. Okay, housing docket A 11523, 9700 Adams Avenue.
Application and fees are in order. Notice of violation is interior, exterior maintenance, no permit, and unauthorized illegal use. Issued on May 10th of 2023. Appeal was received on May 23rd of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name for the record?
Jeff Swisicki, JBS Realty.
Okay, Mr. Swaziski, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, sir, I do.
Okay, go ahead. Let us know what your plans are.
I spoke with the contractor several days ago. He stated that 95% of all the interior work has been completed, and he is going to start on the exterior work as of this weekend. I asked him what the delays were, and there were some delays with regards to a tenant in the process of moving out. The residence is now fully vacant, and he can have full access to do anything and everything he needs to do.
You have a time on when you think it'll be completed?
He asked me.
If I may, Mr. Chairman, if I may interject, this is Attorney Eric Allen. I'm here on this case also. We're actually seeking 45 days is what we're looking for to have it all wrapped up and completed.
How about, I don't have anything from that guy. No, I'm talking about the Jeff guy.
Okay, so I'm gonna
Mr.
swear you
Chairman.
in anyways, because and you're on this case, right? You're on this 11523. Okay, solemnly swear to tell the truth, the whole truth, so help you God. Mr. Ali.
Yes, I do.
Okay, all right. And you're saying that 45 days will handle it, and
Yeah.
the owner is agreeing. Okay, let me go to Mr. Vanover.
So, Mr. Chairman, so there's several violation notices included in here, and I just want to make sure that sorry, I'm actually trying to pull them up as we speak, so bear with me a moment. So the interior work is well underway and it's vacant, but there's also an illegal use. This is 9700 Adams, correct?
Yes.
Okay. So there's an illegal use violation notice. What is the status of correcting that?
Attorney Elaine, okay if I respond?
I believe this property's vacant right now.
Yeah, we inherited this property as a property management company, and the third floor, which is the improper use, has been vacated, and we did that 2 or 3 months ago due to that violation. So that has been corrected.
Okay.
Vanover?
Has any of
Okay.
this been re-inspected?
I don't believe as of yet, sir.
Yeah.
Mr. Chairman, we don't object to 45 days with no further extensions, with the understanding that it'll be inspected as soon as administratively possible.
Okay, so a motion is in order to allow 45 days, November 11, 2023, with no further extensions of time. Motion? Moved. Moved by Mr. Maskey. Second. Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Gallagher.
Yes. I notice to be sent out to you within 2 weeks. Thank you.
Thank you.
Thank you.
Okay, housing docket A 11723, 10201 Union Avenue.
Can we just make
Application
sure
and
that you
fees
guys
are in
aware that
order.
A69 is here?
No,
Oh, hold on just a moment. Mr. Ho, what
Yeah,
is,
we were set first on the docket, and I know you said you're going out of order. I just don't want to make anyone think that we're not here.
oh,
7756
okay.
Broadway.
Okay, we know you're here. Go ahead and mute down. You'll come up at the end, okay?
Okay.
We know you are here.
Thank you.
Okay, go ahead and proceed with, where we were with the
application
docket.
and fees are in order. Notice of violation is exterior maintenance issued on May 3rd of 2023. Appeal statement was received on May 25th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. With the appellant or his or her attorney or representative, please state your name for the record.
Leon Murchison.
Did we catch that last name?
Murchison.
Marriage's son. Okay, solemnly swear to tell the truth, the whole truth, so help you God?
I affirm.
Okay, let us know what your plans are.
I have contacted several roofers. First is a chimney requiring a boom, and the other roofers won't come into the area, and the other roofers I contacted, I booked so far out, but the roofer built more. I still need
when he's going to get started, but that has not taken place. I'm Nadine Bates, Mr. Murchison's fiance.
Okay, well, I'll swear you in also, solemnly swear to tell the truth, the whole truth, so help you God?
I affirm, yes, sir.
Okay, very good. All right, and so again, you were saying that they got back to you, or?
No, sir.
They did not, okay.
We have tried to hire 4 contractors to do this work, and it has been to no avail, and we're trying to get it done. Now, Biltmore was supposed to have their estimate in for us on Monday so we could proceed further. We have not heard a word from them.
Okay, is this owner occupied or rental?
It's owner occupied.
I'm not sure I caught that.
Owner occupied.
Oh, owner occupied. Okay, thank you, Mr. Murchison. Okay, so you don't have any idea on time, do you? As far as getting completed what you think needs to be done?
Not
As soon as we
exactly.
get as soon as we hear back from the builder, we really don't have a time frame. Hopefully sooner than later, sir.
Okay, let me go over to Mr. Vanover.
Mr. Chairman, I apologize. I need the address. Council from the Broadway project talked over the address and I need
Okay,
What?
it's 10201 Union Avenue.
Thank you, sir. Bear with me just a moment. So, Mr. Chairman, as an owner occupied structure, we do not object to more time. I just need a reasonable amount of time. We don't object to 120 days to get this corrected.
Okay. So we're going to give you 120 days to get your contractor in and correct the violations. That would be January 27th, 2024. Motion so in order.
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Gallagher.
Yes. Okay, a notice will be sent out to you within 2 weeks. Thank you.
Thank you.
Next docket is A 121-23 1445 West 50th.
Application and fees are in order. Notice of violation is condemnation of the main structure. Issued May 11th of 2023. Appeal was received June 11th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name for the record? Mr. Chairman, I do not see a Patrick Martin in the participants panel.
Okay. Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Mr. Chairman, to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of this appellant and or docket?
To Mr. Chairman, to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given, the board can proceed with its hearing and ruling. Thank you.
Okay. Mr. Vanover.
Mr. Chairman, we ask that you deny any time and remand this back to the department. This was a demolition of a dwelling unit that was done without a permit, and the foundation and the hazardous conditions left in its place. And the Department of Building and Housing subsequently condemned the remaining portion of the structure with the expectation of emergency demolition to abate the nuisance.
Okay. A motion is in order to deny more time and remand the property to the Division of Building and Housing for any further action.
So move. Second.
Moved by Mr. Bradley, second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Gallagher.
Yes. Notice will be sent within 2 weeks. Docket A 123-23, 3235 West 111th Street.
Application and fees are in order. Notice of violation is condemnation of the garage. Issued on May 19th of 2023. Appeal statement received June 13th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. With the appellant or his or her attorney or representative, please state your name for the record.
Alan Parker.
Did you
Mr.
hear that,
Parker?
Mr. Ch-
Yes.
What's that?
Alan Parker.
Okay, Mr. Parker, you solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know, what your plans are.
Well, for the past couple of months, I've been just cleaning out all the clutter that I accumulated over the years. It was like, I had 15 bikes. So I did that. I had trouble with the garbage, getting that stuff out, because you can only take out the big stuff, once a month. So I've done all that. I came down, I want to save the main structure and take off the patio part, because I know I can fix that up, the main thing. All the frame is fine, and it's just the roof that needs to be replaced. So when I came down to get my building permit to take out the patio, they said that I couldn't do it because it's for a total tear down. So they said I needed a different permit.
Okay, and we're talking about the garage, is that correct?
Yes, yes.
Okay. And, so that's what the violation is, a condemnation on the garage. And from your understanding is that they want it taken down, is that correct?
Yeah, I believe so.
Okay, and you don't want to take it down, is that what my understanding?
No, I'm sure I can save it. I mean, the frame is fine. There's nothing wrong with it. There's a few spots in the ceiling, that are messed up, that I put boards up, to fix it up. The patio part is shot on the side where we put that up like 30 years ago, my grandfather. That part needs to be taken out. But the square frame is good, and the door is a little bit messed up in the front.
Well, to abate all the violations, just so we get this out here, how much time do you think you need?
If 6 months, I could have it finished. I should be able to have it finished.
All right, let me go over to Mr. Vanover on this.
So, Mr. Chairman, to Mr. Parker, do you live here?
Yes.
So,
Been in the family. Yeah, it's been in the family for over 30 years.
So, Mr. Chairman, we don't object to more time. I think 6 months for a garage is a little excessive. We would ask that within 90 days that the work be permitted and abated. If the appellate makes application to correct the condemnation and provides details on what needs corrected and what needs repaired, they will issue the permit. However, you cannot partially correct a condemnation. So if you made an attempt to simply apply to remove and replace the patio portion without addressing the other work, they would not have issued the permit, because you cannot partially correct a condemnation on a structure.
Okay, you got that, Mr. Parker?
Sort of.
Okay, you're gonna have to go down and you're gonna have to come up with some details on correcting to bring this out of condemnation. So that's the whole garage. That's what you're gonna have to do. And we can give you 90 days to abate that violation.
So how do I go about what? How do I go about tearing down? Can I just start tearing down the patio, or?
No.
I would go get your permit first.
So I gotta go
Mr.
get a
Vanover.
permit?
Yeah, Mr. Chairman, just provide details of what you're going to repair on the garage, what you're going to remove, the entire and complete thing, and how you're going to bring it back into compliance. Show the things, the door that needs repaired, the roof that needs repaired, any siding, any additional information that needs repaired. Show all of that in, it could be sketches as long as we can read them.
Okay. And then bring that to the permit?
505.
505.
That is correct.
Okay, yeah, there is a spot where I can write this stuff down.
Okay, so We're gonna give you till December 27th, 90 days, 2023 to abate the violation. Motion?
So moved.
Second.
Motion by Mr. Maskey, second by Mr. Bradley.
Thank you.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Gallagher.
Yes, notice will be sent out within 2 weeks. Thank you. Okay, next docket is A 23523 1310 West 89th Street.
Application and fees are in order. Notice of violation is illegal occupancy, hazardous conditions, no permit, and vacate order. And interior and exterior maintenance. Issued on September 11th of 2023. Appeal statement received September 21st of 2023, requesting 30 days to comply with the order. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Would the appellant or his or her attorney or a representative please state your name for the record?
Albert Thrower.
Mr. Thrower, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Okay, let us know what your plans are.
Okay, basically, I forwarded the deed, and the deed's 50% in my name, and I live on the one side. As an exhibit, I sent some current mail and my driver's license, and I appealed it on the limited issue, like all the renters have been removed from the property, and I got the furnace permit. I got new furnaces in there with the building department inspecting them, and everything was good. Central air. I got a permit. I put a new roof on, new drive, and then all of a sudden, the trial court said that interpreted this order that I was not allowed to live there. So one day I'm living on Zillow, it says $350,000 house, and the next day I'm homeless. So I wanted just to clarify the order that I can live there myself as a resident. As I'm doing this work to meet contractors and to get this up to code forthwith.
Okay. Well, I'll ask you how much time you think you need.
What I'm doing just at the beginning of the week, I talked to a contractor that did the house next door, a realtor, to enter where they rehab the whole thing, and so that's what I'm looking to do. Like just bring in somebody to do the whole thing. Like I have knowledge in this myself, but you know, I'm saying like 90 days. But the main issue is that to clarify that I would be allowed to live in this house. So there is not an issue like when I'm over there. Okay, oh, I got to leave at night. You know, that kind of thing. So that's basically why I appealed it.
Okay, I can tell you that usually, you know, you have to have utilities that are functioning before they're ever going to agree with that request. But I'm going to let Mr. Vanover handle that. I'm going to put that over to him, let him know your time frame, and we'll move on that. I do have, I think there's either the representative or is that Heather? Your representative for council.
Good morning, Chairman Gallagher. Yes, I'm the neighborhood advocate in the Ward 15 Council office under Councilmember Jenny Spencer.
Okay, do you wish to say something now or do you want to wait till the end?
I would like to allow Mr. Thrower to finish his statement, and I can certainly respond when he's complete.
Okay, we're going over to Mr. Vanover right now, okay? And he's going to respond to the comments, and then maybe it'd be best you come in after that, okay?
Well, I do have one question,
Can we,
Chairman
Mr.
Gallagher.
Chairman, can we get
Yeah.
her sworn in first, please?
Yes, I'm sorry. Let me get you up here. Okay, so, Ms. Lazar, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, all right. So we're gonna go over to Mr. Vanover. You do have a question. Go ahead and ask your question.
I have a question for Mr. Thrower at Cudell Avenue. So I'm just wondering if he can live there while the issues are being addressed at his property at 1310, 1312 West 89th Street. And it is my understanding, based on a housing court appearance just the other day, the date was the 25th, the order to vacate was due to many violations that I'm sure Commissioner Vanover will elaborate on, but it is a sheer safety issue, and it is just an unsafe place to live.
Okay, so do you want to answer that, Mr. Thrower?
First of all, the 9820 is fully rented with rental permits, lead certificate. So that is not an option. And when the HVAC inspector, I think his name's Ewan from, he approved the new furnaces that I installed with the central air with the permit and all, and he was out there and I spoke with him, and if there were any issues, and he gave me the green light that everything was up to code, and the new roof with the permit was up to code, and the new drive, there wasn't an issue with that. I was over there mowing yesterday, and then to sit there and say, oh, this house is unsafe. The utilities are on. It's I've lived in this house since 2008 when I bought the house, and it had a permit to turn on the electric there, so there was not an issue there. So it being unsafe, I don't think the councilwoman representative, Ms. Lazar, has never been in the house, and she's not in a position to give expert testimony that it's not safe. And I would just like to clarify that I would have permission to live there. The trial judge said that I could go in, meet the contractors, do the work and all, but it would facilitate me. I had prostate cancer. I was treated at Metro Health, and it would just facilitate me living there.
Yes,
Okay.
but Mr. Thrower, if you recall, Inspector Darrett with the Building and Housing Department did not mention any of the issues that you're discussing, the driveway, the roof. It was the wiring. In the process since 2008, when you purchased the property, you
Okay.
installed 13 bedrooms. And so it's the faulty
I would
wiring and
object
egress.
to this testimony because there's nobody in the house right now. And
Mr. Chairman,
As it
if
should
I
be.
may.
Okay, hold on. There's a vacate order. We're going over to Mr. Vanover to go
Mr.
ahead.
Chairman, can you hear me?
Yes.
Okay, yeah, if I could actually speak to what my inspectors found and saw. So there's a couple things that are in play here. There was a court case from an initial notice of violation where the court ordered that the property, that the tenants be removed and that the property be emptied. That is a court order on a housing case that is not before this board, and the board does not have the authority to overrule a court order from the housing court judge. Subsequently, there is a notice to vacate that was issued by the Department of Building and Housing that is under appeal. There's an illegal use violation that's under appeal, and then there's a no permit violation notice that is under appeal. So where we are is that the inspections conducted by the HVAC inspector are specific to that work. The inspections for the roof are specific to that work. But the work that the appellant has done on the property is unsafe. There are electrical hazards, there are egress hazards, and there's other dangers in the property. And while I understand that this was his residence that he lived in, that the work that he has completed has created hazards for his tenants and himself. So now he's in a position to where our position is that the property should not be occupied by any person until proper permits are pulled to rectify the electrical, the egress, and the structural issues. So we would ask that you deny any time, that you uphold the notices as properly issued, and you remand them back to the Department of Building and Housing, because this is a hazardous condition and it is dangerous. And secondly, understanding that regardless of the orders of this board does not have the authority to overrule the decision of the housing court.
Okay, so, you got that, Mr. Thrower?
Right, I would just like to rebut that in that the housing, the discussion in the housing court was not clear as far as being able to first of all, the order says I'm allowed to appeal it. Okay, I'm looking at the order there on the exhibit on the right side. So it says you have 30 days to appeal this order. So I did appeal the order. So my opinion is that it is properly before this court, because it says order. Even the trial court was, she didn't think that I had, she wasn't aware that I had lived, that was my residence. And so I appealed it with on the limited circumstance that I can continue to live here as resident. I mean, there's no tenants in the property. The property's secure. I mean, there's issues like somebody might be breaking in, that kind of thing. And I've lived in this house since 2008.
Okay, I hear what you're saying. The problem is there is a vacate order that is in place. And although you say you're appealing the city is saying to you, you have to get those things that are creating this to be a problem permitted and taken care of before you can go in there and before they'll lift this vacate order. So I can't, and so it stands. And all I could tell you is that you need to get someone in there to correct those especially I guess it's electrical problems, but you need to get that corrected. Whatever was done before, either unpermitted or whatever happened, you need to correct that, and then you can once again try to get this vacate order lifted. Once you get it inspected, I'm sure it won't be a problem. Okay, so what's before us is a motion is in order to deny more time, remand the property to the Division of Building and Housing for any further action.
So
Motion?
moved.
Moved by Mr. Maskey. Second by Mr. Gallagher. Call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Is he on?
give us one sec. I see him here. I think we have an issue with his mic. One second.
Okay.
Okay, Mr. Chairman, can you, redo that motion? I have Mr. Bradley on speaker.
Okay, a motion is in order to deny more time, remand the property division of building and housing for any further action.
So moved.
Yep, moved by Mr. Maskey, second by Mr. Bradley.
Mr. Bradley?
Yes.
Mr. Maskey?
Yes.
Mr. Gallagher?
Yes. Okay, Ms. Lazar, I'm sorry I didn't get back to you, but I think this is probably what you were hoping for anyway. Is that correct? Okay,
Yes,
very
we
good.
extend our thanks to Commissioner Vanover and to the board. Thank you.
Okay, very good. All right, notice will be sent out within 2 weeks. Thank you.
Thank you. Thank you.
Okay, we're going to go back up near the top there to docket A22623.
Application and fees are in order. Notice of violation is condemnation of the main structure. Issued on August 3rd of 2023. Appeal was received on September 7th of 2023, requesting for time to abate the violation. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name for the record?
Good morning. This is Attorney David Lenahan on behalf of the property owner.
Bradley.
Hello?
We can hear you. You gotta be quiet.
Okay, we're having a bunch of people talking here. Okay, Mr. Lenahan, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, sir. Sir Chairman, we would request that this matter be rescheduled. The reason for that, no harm or prejudice will come to the city. On August 3rd of this year, the notice of violation was issued on this property, which stated that a permit to abate needed to be applied for within 30 days. The property owner was in the process of doing that. However, the property was demolished by the city, and I'm in a precarious situation trying to figure out the legal ramifications of the property being demolished during the due process time period that the property owner had to pull a permit, which he was doing. So I don't think there'll be any harm by rescheduling this to a later date as we figure out what the legal ramifications may be. Just for purposes of disclosure, we did file this request for an appeal, even though we knew the property had already been demolished, just to preserve the record and make sure that we were doing things correctly. But just letting you know that I believe the property was demolished maybe within 12 days of the notice of violation of August 3rd. So I have to figure out some things on this.
Okay, Ms. Davis, can we reschedule them?
Mr. Chairman, yes. Would the attorney on this case please contact this office so we can discuss
Yes.
a rescheduling time frame?
Yes, can I have that phone number so I can don't have to look it up?
I'm sorry, could you repeat that?
May I have the phone number to call so I don't have to look it up?
Oh, sure. It's 216-664 2418.
Thank you, and thank you, Chairman.
Okay, thank you. No action will be taken on this. Okay, next docket, A6923, 7756 Broadway Avenue.
Application and fees are in order. Notice of violation is condemnation of the main structure issued on February 21st of 2023. Appeal was received March 27th of 2023, requesting for time to abate the violation. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson, Department of Law. Would the appellant or his or her attorney or representative please state your name for the record?
So I'm the attorney. My name is Brett Hall. The
Okay.
representative is here also.
All right, Mr. Hulk, solemnly swear to tell the truth, the whole truth, so help you God.
I do, but
The first
my
one.
client is here to testify also.
Okay, who's your client?
Shelley Liverpool.
Okay, and they're online, they can hear?
Miss Liverpool, can you hear? Can you unmute yourself, please?
Okay, solemnly swear to tell the truth, the whole truth, so help you God, Miss Liverpool? We need to hear her.
Sorry, I couldn't get my phone off mute.
Okay.
Yes, I do.
Okay, very good. Okay, go ahead and proceed.
Okay, ma'am, please state your, what is your involvement with Cleveland Property Management Foundation, LLC?
Manager alongside Eric Jones.
Okay, and does Cleveland Property Management Foundation, LLC own 7756 Broadway Avenue?
That's correct.
Did it acquire the property on 10/12 of 21?
Yes, that's correct.
Okay, and is that indicated in our exhibit 1, page 2? I'm sorry, our exhibit packet, page 2.
Are you
I'm sorry.
asking me or?
Yeah, I'm sorry, sir. You guys have the board has the exhibits pages 1 through 300. Is that correct?
I believe so. Did we have all 300?
Move a little faster. Instead of asking the client to identify within the pages, I'll just refer to the page numbers just to move along.
Okay.
Okay. Ms. Liverpool, is the property small detached retail property class?
Yes.
Okay, and that'll be page 4, Your Honors. Is the condition identified by Cuyahoga County average condition? The condition is known as average, page 7 and 8, Your Honors. Ms. Liverpool, can you just confirm the county describes the property?
That's
condition as
confirmed.
average? Okay.
Yes.
Okay, at any time between October 12th, 2021, when your entity purchased the property and today, was any condemnation notice recorded with the Cuyahoga County Fiscal Officer Recorder Division?
No.
Okay, and that'll be Exhibit 2, and that'll be page 10, Your Honors. So despite there being no formal condemnation notice, did the property have a partial demolition done? And that's going to be on February 20th of 2023.
Yes.
Okay, and our Exhibit 3, which is page 11, the city sent a bill for the amount of $120,100.105.47. Is that correct?
Correct.
And then several months later, we received a second bill increasing the amount to $150,131.83. Is that correct?
Yes.
Okay, and that'll be pages 11 to 12, Your Honors. Have we, Ms. Liverpool, have we disputed this with Douglas law?
Yes.
Okay, are some of the proof of the dispute marked as as pages 13, 14, and 15 in the packet here?
I'm sorry, you chopped out. Can you say that one more time?
Are copies of some of the pages indicating the dispute included in our exhibits as pages 13, 14, and 15?
Yes.
Okay. And has the city responded in any way to our dispute about the cost?
They have not.
Okay. So, ma'am, if I could just take you back to actually February 17th of 2023, if you would, and describe to the board just what happened from the start of that date onward.
Yes, so I received a call around 1 p.m. on the 17th, I believe from Bob Bauer. He was stating that he was at my property and he was demolishing it in the next hour. He said, yeah, he was demolishing it in the next hour. And I'm like, I don't even know what you're talking about. Like, we had didn't receive a notice. I had already spoke with, I believe his name is Keith, on Wednesday, and we had a meeting set that Monday because he's like, oh, I want to come in. I just want to check things out. I want to know kind of your plan. He works with the city. I also informed him at that time I was in Salt Lake City working. I work with the NBA. So he said, well, you have an hour to get someone down here on your behalf. So I sent someone on my behalf. And I said, well, I'm not, he's like, I'm demolishing it today. And I'm like, I was so caught off guard because I had no idea what he was talking about. He's like, oh, this is a danger and it needs to be immediately demolished. I'm tearing it down today. I didn't understand, he's like, well, I'm taking it down today. That was essentially how our conversation went on the 17th. And like I said, I had a representative arrive there on my behalf to take pictures. That process is just, I've never heard of a process like that because they didn't even demolish it on the 17th. And to charge someone 150% of a cost where I could have had someone else come in. If I would have known, I could have even had the 3 days, considering they didn't tear it down until that Monday. I could have done it myself for 75% less of the price. And you can see in some of our exhibits that we provide some quotes from additional companies to tear down the whole building, which is more than the square footage of what was torn down for that price. And just to add additionally, them tearing down a portion of the structure was unnecessary because the only thing, as you can see in the pictures, Brad, do you know exactly what picture that is in the exhibit where you can see that front decorative piece tearing away?
I believe that's going to be page 77.
Okay, yeah, it's up. I see it here on the screen. As you can see, that's just a front decorative piece. That's not supporting the structure in any way, shape, or form. And that was the only piece that needed to come down. As I said, Bob Bauer forcefully, he pushed me and he said he was tearing it down that day. And that's pretty much how it went on the 17th.
Okay, and just to be very clear, you had not received any notice of violation or any
No.
other formal notice from the city? You just, the phone call was
Absolutely not. No,
the
there's
phone
no
call was the first thing you
documentation.
heard?
No.
Okay. And the violation notice that you received said you had 30 days to appeal. Is that correct?
Correct. Yes.
But was the property torn down before you even received the violation notice?
Correct. The
Okay.
property was also torn down before the city even had a permit to tear it down.
Okay.
And I shouldn't say the property, I should just say a portion of the property because the other 2/3 are still standing.
Okay. Now and your previous answer touched on this. Do you have any sense of reason to believe whether the cost of the demolition the city is charging you is reasonable?
Absolutely not.
Okay. Well, and you did say that you sought out other quotes on the demolition. Is that correct?
Correct. And we've provided that documentation in some of the exhibits. I'm sorry, I don't have the exact number, but we have provided it. And just for reference for everyone, that quote is to tear down the entire existing structure, which is almost more than 2/3 of the portion that they torn down.
So the portion that they tore down was about 1/3 of the size of the total structure?
Correct. A little less
Okay.
than 1/3, but we can just say 1/3, for exacts to give everybody a picture.
Okay, and the demolition quote you received was for, that's page 18 of our exhibits, is that correct?
Correct. And that
Okay.
includes all of the same process and procedures that the city takes. So that would be an asbestos inspector on site. That would be the haul away. That would be the fencing, et cetera. Everything of the same of what the city claims they provided.
Okay. Did we, did we seek an explanation from the city for the cost and even for why the demolition was conducted?
I believe we did it twice. Brad, if you want to correct me, I believe we reached out on 2 different occasions.
Okay. And do you know whether I reached out to Dave Roberts in the city?
Correct. Yes, you did. I also took it upon myself to reach out to the company that the city claimed, not the city claimed, but the company that did the demolition, which is American General Builders. I reached out to them over 8 times and left voicemails. I even went to the place of business, which doesn't exist. It's a cash check loan place. So I'm not sure where that company came from or how the city sought out that company, but it's impossible to get in contact with them. So I'm not really even understanding how the city did.
Okay. And Mr. Roberts indicated that the city's position is that the area, the quote, small area, he called it the small area. He said it was the
'Cause it
leading
is.
edge of a collapse of the entire roof. Do you have any response to that factual allegation?
You can even see in the pictures, there's no collapsing roof. It is just the front decorative piece that was detached from the building, which doesn't even provide structure for the building.
Okay. And just hypothetically, if you had to replace the roof on that property, just the roof, how much?
Say on the high end, 20K for the entire roof of the building.
Okay. And just for purposes of record, it's $20,000.
Correct.
Okay.
And just for the record, also, I can make that assessment because I've done tons of work on other properties I own, so I can make that assessment confidently.
Okay. Okay. And now you've talked about some of the procedural history here. Let's just go through the documents themselves. If you look at page 25, is it safe to say that the declaration from Mr. Vanover was issued on February 22nd, 2023?
Correct.
Okay. And your honors, that's page 25. So the demolition instruction, excuse me, the condemnation under the claimed emergency situation wasn't actually issued until 2 days after the city had already removed and done the work, correct?
Correct.
Okay. And there never was a condemnation order recorded with the Cuyahoga County Recorder. Is that correct? Okay. The city, how many bids did the city obtain for this work?
To my knowledge, none, because I don't even think the bid was submitted until the beginning of March, if I'm not mistaken.
And so if you look at page 28, was the date of the bid March 3rd of 2023?
Correct.
Record number CDR 23-0046.
Correct.
Good. And there was a reference in the bid itself to maintain footers on Broadway Avenue and maintain temporary fencing. Were these things ever actually done?
No. I provided some of the pictures from my representative who was there on my behalf. It was just some caution tape. And then additionally, and I don't, just to add, I don't know if it's a requirement of the city, but it may not. I just want to give all the information that I have possible. As far as safety precautions, they left the structure extremely exposed during those days of demolition, because I believe it went on for about 3 or 4 days, if I'm not mistaken, and it was just open and exposed.
Okay. And then there's a reference in the request for proposal to demolish to, quote, must submit EPA notification to Demo Bureau before demo. So they had to submit Environmental Protection Agency notification to the Demolition Bureau. Do we have any proof that the city did that?
No.
And we'll come to it later, but we actually requested we made a records request from the city for all documents relevant here. Is that correct?
Correct.
Okay. The violation notice, and this would be page 30, your honors, was issued, the claimed issue date is February 21st. Is that correct? I'm sorry, Ms. Lure, is that the
yes, that's
violation
correct.
of February 21st? So again, after the property was already done, it was already torn.
That's correct.
And it did issue the 30-day notice. We filed our appeal. The true copy of that is included. Okay. Separately, among the things that you were notified you could do from the city is that you could submit like an architectural drawing.
Mm-hmm.
You recall that? Have you done that to this point?
Yeah, so we have a proposal, and we're working with an architect if you guys, need to see that proposal. But yes, we have started that process.
Okay. Okay, the city also issued a quote notification of ordered emergency demolition on page 40. Is that correct?
That's correct.
And the date of that notification was February 27th. Is that correct?
That is correct. And that's after they had demolished the entire third of the structure.
That's a whole week afterwards. Is that correct?
Yes.
And the notice itself indicates the demolition is expected to have occur, 2 weeks or 10 days prior on February 17th, correct?
Yep, that's correct. Even though I
All
was told it was coming down on the 17th and I didn't have time to put anyone in place to rectify or, even just object on my behalf, because I was told by Bob Bauer that it was coming down on the 17th on a phone call in 1 hour.
Okay, now if we look at page 41, starting there, are these copies of photos the city gave us?
I believe so.
Okay, yeah, and you see like a number written at the bottom, page 5, 7756 Broadway.
Yes.
Would it help if I shared my screen? I don't know if I'm allowed to do that.
No.
Okay. All right, so the first photo demonstrates the facade pulling away, but not supporting the roof or the structure otherwise. Is that correct?
That is correct.
Mr. Chairman, to Attorney Bauer, the following exhibit that I have put in the PowerPoint presentation for you would be Exhibit 8, Exhibits 14, 15, 16, as well as the video. So all picture evidence that you submitted to the board, I have included in the PowerPoint presentation today.
Okay, and we did, well, page 50 is exhibit 10, and that's our public records request. Just shows we're requesting all records related to this parcel number and the adjoining parcel number since June 1st of 2021. So we just would like to call the board's attention to corroborate what what my client said a minute ago, that we requested all records and haven't received the ones that she's talked about. Page 54, this would be the permit, and this actually shows that the permit was not applied. It says issued on March 2nd of 2023, which again is 2 weeks later, and it identifies the person who obtained the permit, I think, as Nair Al-Mahdi of American General Builders, LLC.
That's correct.
Yeah, we also include the duplicate copy of the notice here because I think the city gave us that. Let's see, as far as Miss Liverpool, do you have any reason to believe the city has not complied fully with the public records request?
Not. And we have obviously, paper trail evidence of us asking multiple times.
Is that
Mr.
true?
Chairman?
Yes.
Mr. Chairman, if I may, a couple of things. There's a vehicle, there's a venue by which the appellant can object to the cost of the demolition. this board is not it. There's also a venue that the appellant can object to our responses to public records requests. This venue is not it. I would ask that the chairman and that the board keep the testimony and keep the presentation to those items and those things that are within this board's purview. And I understand everybody's, just trying to make their record here for, whatever happens past this board. But I would just like to point out that these are not items that are under this board's authority.
Okay, and so basically what we're looking at is the emergency demolition when they did it, and I guess that's some of the relevant stuff here, that the city acted when they did. Why did they act when they did? And I guess that's things that'll come back to you, Tom.
If I could just respond to that, though, I mean, I don't totally, I would preserve the argument that this board can hear these things, especially about the charges, because, the Cleveland Codified Ordinances lay out, a bid process. They lay out what happens here. And I think that's, if Mr. Vanover is referring to the way to object to the bill directly, I think that's an additional thing. But I don't think that supersedes the ability to argue for that here as part of this board or separately in court.
Yeah, well, I mean, using that argument to say that, well, look what they charged. They jumped in here and did this, and we could have got it done for this. I get what you're saying there, so that we're just aware. But I think the main objection here is that it got a part of the building got tore down before you were going to do it. Let's say that you had plans to tear this down, I believe. That's because you were getting bids, and so that seemed to make sense. I got Miss Liverpool's hand up.
Yes, I put my hand up. We got those bids after the fact, and and apologies for any ignorance on my behalf, because this is the first time I've been in a situation like this. I hear the point of saying, sure, yeah, we could have got it done, for this or et cetera. And I understand what an emergency order is. The attestment to that is, yeah, we could have got it done for this or even other numbers, but 120,000 for bids that are in the 30 for the entire.
Mr. Chairman, I'm going to object again about the discussion around this bid in this venue. This is not the proper place for it.
Okay. All right.
Well, and my apologies, Mr. Chairman. I'm not still trying to push on the fact, but to lead back to the fact, which I believe is what this board can attest to, the part about the emergency order, it being taken down, before even the city had permits in place and et cetera. I think that does hold relevance to this board. And again, if I'm being ignorant by speaking on that, my apologies. But
all right, I have our architect, Mr. Maskey's got his hand up also.
Okay.
Mr. Maskey.
Thank you, Mr. Chairman. Mr. Chairman, to the appellant, are you a licensed architect or engineer?
You're asking Ms. Liverpool?
She's the appellant, correct?
I just want to make sure you weren't trying to ask me. Yes.
I am not, but we have an architect in place who is licensed, who is handling the drawings on this.
Okay, they're handling the drawings, but you keep referring that this is a decorative item.
It is.
Well, with your expertise, can you explain to me why that's decorative?
Because if it wasn't decorative, it doesn't have to be angled the way it is. It would follow the same shape of the structure. So from the previous owners, that was something that they put up, considering we obtained that in October. And you can see from the pictures of the structure, even in the Google history, but that's been there. And my additional inserts of saying it's additionally decorative is it doesn't provide any support to that building.
So the photo that I'm looking at, it appears that it's pulling away from the facade. Is
That
that
is correct.
And was that initially plumb, or was that always pulling away from the facade?
That initially was connected to the building, and excuse my
Yes.
ignorance, I don't know what plumb
Okay,
means.
so then I would contend that this is not a decorative item. That probably adds to lateral stability to maintain the brick wall from the second floor up. The roof needs that wall for structural integrity. So with that pulling away from the building, I guess my question is, why was it neglected so long and not repaired once it started to pull away?
I have pictures from even just a little bit before that had just had to happen. Like
Okay,
that
so
was
if
so,
it,
and I don't know how.
so
The-
I'm very familiar with buildings. I own many that I maintain
Okay.
within the city of Cleveland.
Okay.
And if something was moving that rapidly, it would need to be addressed immediately.
Would it need to be addressed immediately with notice?
It would need to be addressed as immediate as you knew it was moving. And I would
The minute
argue
I knew,
that,
so
ma'am,
the minute I knew it was
ma'am,
moving.
ma'am, I let you talk for a long time.
Okay,
Please let me finish.
okay.
If that started to move, it would not move that aggressively to get to that point. Because if it moved that aggressively to get to that point, it most likely would have collapsed. And it's over a right of way where people walk, and someone could get severely hurt or possibly killed. So I think, however this was addressed, that building should have been repaired or taken down in an emergency situation. And this is not a decorative item. And I would find it very difficult for any professional licensed architect or engineer to argue against that, knowing how buildings go together, specifically of this vintage. So I would not keep saying that.
I'm sorry, can we,
I was gonna say, can I respond? I didn't know if I was able to respond to that. I just also want to add for the record that I had been left a business card for someone in building and housing. And that, as I stated, that was on Wednesday and he was at my property. And that was not brought up in any of our conversation.
also, did Mr. Maschke inspect this property at the time, or is he just looking at the photo here?
No, I'm responding to what I see before me today.
Okay. And is he, you're a city witness? Has he been sworn in?
I am on the board.
Sir.
And just for reference for everyone, Russell Katakatoon from the residential building inspector is the one who was there Wednesday, who I had a meeting with that following Monday.
Right, and I think the one thing we'd clarify is that the bids that my client solicited came after it was torn down. I think the preparation she was doing is that she had already scheduled a meeting with the person she just mentioned for the following week. But in the meantime, the city came out, notified her, told her she has 1 hour, and then told her she can't do anything else other than let the city tear it down. So, Ms. Liverpool, if you just confirm that.
Mr. Chairman.
That's
Chairman.
Right, I
and-
understand, Mr.
and
Mayor, I got
If I
that.
could respond to the misrepresentations in those last couple of statements when my opportunity provides. This is
Okay.
Tom Vanover, Chief Building Official.
Okay, it just, I have only a little bit further to go with my client here. Exhibit 14, which includes photos. You mentioned about a fence, that there was not a fence up at any point. Is that correct?
From my representative, the reports back and some of the photos, no.
Okay. And
And I
our
also just
exhibit,
want to add, Mr. Robert, in no way am I trying to insult, obviously, your expertise because you're a licensed I know you're a licensed architect. I just want to add that, for the record.
Did the permit was actually paid for on March 27th, 2023 in our exhibit 13, is that correct?
Correct.
Okay, exhibit 14, this would be photo number 77 and 78. Is this, who took these photos?
Sorry, I'm just scrolling. I took my representative took those, as you can see my face. Took 78 and we pulled, took 77, as you can see my face in that one. And then I just pulled to still kind of just show that frontward piece from the Google search.
Okay. And so the structure is still up here, obviously in these photos being taken.
That's correct.
Is that, what do you, if you can look at 78, what does this photo depict in your opinion?
Again, I don't want to insult Mr. Robert, where I don't want to use the words decorative, but to me, it's just a piece that it doesn't provide any support to the structure as its entirety. But again, like I said, I don't want to insult or offend him.
Mr. Chairman, is this photo on the screen?
No, I don't see the one where.
They said he's not allowed to share his screen.
It's marked as exhibit 15.
Oh, okay, is that in the stuff you sent? I don't think there's any.
Yes, it's probably, it might very well be the very next image there for you guys.
Exhibit 15.
Okay.
Exhibit 15. Yes.
No, it's actually it's a lot deeper in.
Okay.
If we can get to, there you go, 15 right there on the screen, the one in the middle. Okay, and ma'am, this
For
is
the
a
record,
photo.
you can tell him the picture on the right is the American General. I don't want them to confuse that. That's the American General Builders location, the check into cash.
Okay, and we'll come to that in a minute. We're looking just solely at the image right in the middle of the screen there, the 7758 Ohio 14. And that's a photo actually from Google Earth, correct?
Correct.
And does it, in the lower left-hand corner, do you see a reference that this photo was taken 8 months ago?
Correct.
Okay, so this photo was prior to the teardown.
Yes.
Correct.
Okay.
Okay.
When was that photo taken? I mean, so this was a Google Earth photo taken from when?
I'll just represent, we don't have a precise date. However, when I printed up the exhibits and submitted them originally on September 8th, this Google Earth photo was marked as 8 months ago at that point. So
September 8th. So it's quite likely that the day that we were there, when this structure was, when this front lateral parapet wall was flapping in the wind, that Google was there as well, without actually having a date, because 8 months, February, that's.
Well,
8 months is in February, and that would be more so in the January space.
Mr. Chairman, I would ask that they either provide a date or don't.
I'm going to provide.
We've already indicated we don't know what precise date Google Earth took this photo, but it was sometime shortly prior to the date of the teardown.
Now you're talking about the one on the left?
I'm talking about the one in the middle.
Oh,
the one in the middle. Yeah, where it's daylight. It's daylight outside. We're really additionally providing that because we didn't negligently ignore this issue. If I knew about it prior, why wouldn't I repair it? I wouldn't just leave it. That doesn't make any sense.
Okay. All right.
Okay. And just a limited issue here. So do you have any concerns with who the contractor was that the city chose for this?
Mr. Chairman, I object. The city has a policy and a process for choosing contractors. The fact that the contractor did not respond to the property owner is irrelevant. They have a contract with us. We have city records and city sunshine laws that we have to apply for. The contractor has no responsibility, and there's no value. And I object to any of the appellate's presentation on how she feels about who and what the contractor is.
Well, I
It's the
think we
city's
would,
responsibility
My
to
objection,
provide a
my
breakdown.
he does not, it's the city, it is the city's responsibility to provide all records kept in the course of business. And the contractor's responsibility is to respond to the city, not to the, not to you, not to the persons that, the property owners. So
Which I
my
understand,
objection is heard. If I can
I
finish,
understand
please.
that.
If I
Okay.
can finish, to the counselor, my objection has been made. Board can do as they wish.
Okay.
we just,
Mr. Chairman, I don't know if I can interject. I understand the process of them having to provide information to the city. I'm past the point because only clearly the city can get in contact with that contractor. My more so case is we've directly reached out to the city to ask for a breakdown of charges and the expense, and we've yet to be provided that. And like I said, I don't know if that's a requirement, or as Mr. Vanover said, maybe that's a different chair or board that we need to speak to in regards to that, but we have requested it multiple times because like I said, I understand the contractor not speaking, or providing information to me. I wouldn't be able to get it anyway because that company, you're unable to get in contact with that company
No, Mr. Chairman, I object.
unless you're the city.
I'll continue my objection. So I am not unable to get, yes, as the city, we can reach out to them. So.
Okay.
Yeah, can we
Mr. Holt?
request, can the city request those and provide them to us if that's at all possible?
Yes, so you've made a public records request for looking for those documents?
Yeah, we've made 2 public requests to have those documents provided well before this court date, and we've been ignored both times.
Mr. Chairman, this is Dan Jacobson from Law. I just wanted to interject that the city is going to object, and will continue to object to testimony regarding costs. We're allowing Attorney Hall to present his case and hear from him, but that will be an objection and an ongoing objection to testimony regarding costs.
Okay.
We have heard information regarding notice. That notice, the appellant has received phone calls, various notice of the emergency violation. The pictures clearly show that there's a structural defect in the building. I don't know if that is disputed. The emergency existed, there was a CBO order given, and the matter before the board is the condemnation of the main structure. So the city just states its objection to continued evidence and testimony regarding costs.
Okay.
our closing here is not about the cost. It's about the actual choice of the contractor. This Nair Al-Mahdi, I mean, you've probably heard multiple times before, has a fairly extensive criminal history.
Mr. Chairman, I object.
He lists a business address that doesn't
I'm
exist.
sure there's
Yeah.
going to be multiple objections. I'm sure.
Okay.
Well, no, wait a minute. I objected. I want the chairman to rule on the objection to where either you can continue with your discussion about the contractor chosen by the city legally under our ability to choose and vet contractors. And I want the chairman, I would like the chairman to either say,
Mr. Vanover,
yes,
you are
you can
correct.
continue, or no, you cannot.
We're not going to continue on that, okay? That or the cost. So you've made that point very clear, Mr. Vanover, as to how that happens, how that occurs. Mr. Ho, have you wrapped up?
I would just, within the context of what you just said, I think we would just emphasize in closing that you know, in terms of the notice, my client was specifically told there was no other option and he was taking it down. And she was deprived of the ability to do anything herself on an immediate basis. You know, we're not, you know, where she could have had the option to do it for a lot less money. Then it turned out that they didn't actually tear it down then. So she was given over the phone oral information that wasn't correct. You know, this is legal, this is law, there's process, there's due process, there's notification, and this just didn't comply with it in any way, shape, or form. And then the bid itself, you know, just comparing what the bid said it was charging for, the photos show that it didn't do half the things it said it was going to. No fence up, you know, no EPA notice, the things we've mentioned here.
The requirement from the city also, Brad, if you
Right.
want to add, that's what the city's supposed to add. And I can move past talking about the cost and the contractor. Like I said, I've heard that the city has their process in place, like you said, but my due process was violated, which if I would have known I had till Monday, I could have took it down myself. But Bob Bauer gave incorrect instructions to me on that Friday about what was going to happen. And I'm assuming we can discuss that here. But, you know, since that process didn't happen, the city took it upon themselves and they tore it down. They have a process in place for bids, et cetera, which is cost. They've stated that they're going to provide the breakdown, but the underlining fact is I was told on the 17th it was coming down the 17th. It did not come down until that Monday, Tuesday, and Wednesday. And then aside from that, the city did not have permits even in place to take it down at that time. Because
Okay.
they sent a 30-day appeal notice, but they took it down before the 30 days. So I'm not understanding.
Okay, well, we're gonna find out. We're gonna go over to Mr. Vanover and have him explain some of this stuff.
Okay.
Mr. Vanover?
So thank you, Mr. Chairman. Just to begin as to keep the record clear, I was not privy to the conversation between Ms. Liverpool and Mr. Bauer. I don't actually believe it happened. I spoke to Ms. Liverpool.
I have evidence
Excuse
that it
me.
happened. Okay.
Excuse me.
Just wanna ask.
Ms. Liverpool, I spoke to you personally
Okay.
that morning, and we discussed it. Sitting there in front of your building, myself and manager Kevin Franklin, watching the building. And if I can point the board to the photograph, the first photograph from the sidewalk, as we were sitting there watching this structure after receiving the complaint, this point in the leaning of the front facade is about at its midway point. So as the wind blew, it went equal distances to the left and to the right, and it was in considerable danger of collapse. And had it collapsed, it would have taken out the power lines in front of it as well. You can see from this photo that the only thing actually holding this wall in place was the lowest bolt from the green awning on the base of the structure. So in speaking with the appellate, she was out of town, and we explained to her the condition of her property and the problems, and that it was going to, had this wall given way, it was going to be extremely hazardous for for anybody, and that the building would subsequently collapse, damaging this portion of the structure, as well as the two adjacent sections next to it. We asked her, she said that she could get somebody there, send her contractor there to look at it. And then nobody came. And then nobody came. And then somebody finally did come, but he was not a contractor. He was just somebody who had worked in some capacity that had no decision-making ability whatsoever and was just there to take photographs. This is what he said. This was his words. I couldn't, upon even attempting to, could not get his name. But he said he's just here to take a look at it. And at that point, he took some pictures. The front wall, this is, as Architect Maschke has said, this wall provides all the lateral support for the building and the masonry wall and the roof. Once this wall is gone, there will be collapse of the second floor and then impacting the first floor. If you can go to the second photo, you'll see that the rear roof, that the ridge board for that roof has subsequently has also began to fail. Any change and shift in the front portion of this building would definitely affect that, whatever's left holding that in, which is why that ridge is appears to be approximately 18 inches out of level. We had considerable conversation with Ms. Liverpool that day. I did, not we, I did, about the need to take this portion of the building down where multiple requests to not touch the rest of the building if we didn't have to. And we confirmed at that point that we believed at that point we could remove just the hazardous, neglected, dangerous portion and leave the balance of the building. And that I explained to her that if she was unwilling or unable to get her own person's contractors here to take care of it, that we would be mobilizing within the hour, and that we would raise the building as quickly as administratively possible. I personally began working with the auto repair shop next door and getting getting them to move cars and to reorganize. I spoke with the traffic unit to allow them to park their cars onto the street so that we can gain access to that. My position is that it was an emergency. As an emergency, the state of Ohio Administrative Code allows for us to act and abate the violations and abate the hazard, abate the nuisance, and abate the risk without submission for a plan approval or permit on an emergency basis. The City of Cleveland Codified Ordinances affords the Director of Building and Housing in emergency situations to contract to a qualified contractor without bidding or advertising. Our position is that the front wall was failing, which was going to cause the rest of the building to fail. The fact that the appellant had owned this building for 2 years and didn't see that the front wall was rotting. This was not an emergency. This was not a weather emergency or a natural disaster. This was a somewhat windy day that caused the condition of a neglected building to come apart. And so it's not that it was immediate and happened suddenly. The front wall was disconnected from the rafters, from the ridge board, and from the roof by virtue of the fact that it had been improperly or not maintained at all. And it literally just, the connection rotted. So to that point, we are within our authority to raise the structure because it was dangerous, because it was hazardous. We were within our authority to do it without permits, and we were within our authority to sole source the contract. So to that point, during that conversation, I did say, we are going to raise it. We're going to mobilize within the hour. She needed to get somebody present on site that could address it. That did not happen. Her representative told us that he did not have the ability or the authority to start doing anything. And so as soon as administratively possible, we concluded and conducted the demolition. And if without having the actual times and records, if the demolition didn't happen till 2 days later, at any point during that time, I mean, I never did I say that we are going to tear it down and that's the only remedy.
You did say you were going to tear it down in an hour.
Mr. Chairman, yes, I did, but I never said that's the only remedy. I
You
never
did
said
say
that.
that's the only remedy. You did say, now, for the record, Chairman, as I'm listening to Mr. Vanover speak, he is correct. Mr. Vanover is actually who I spoke to, so he is
Oh,
correct. So
interesting.
for yes, as I'm listening to it is you. Bob Bauer
Okay.
is just the one who was on the document. So yes, you are the one I spoke to. So
I'm
you
aware.
said
Thank
I
you.
have an hour to have someone come here and explain to me, oh, what do they do? What are they gonna fix? And I stated to you, can we not, especially when I got the pictures, can we just take that front piece down? Mr. Vanover is correct that he did say he was going to attempt to salvage the, just taking quote unquote that front portion down. I do recall that conversation also. And I guess we can sit here to agree to disagree, but it was stated to me that that building was coming down today. And you didn't take it down until Monday, Tuesday, and Wednesday. And I even understand the process of you can, with an emergency order, you don't have to be permitted and all of these things, et cetera, which is, that's fine, because obviously that's factual. But I also understand now that since you're the one who I spoke to, I understand your objections of wanting to provide the cost because of the personal relationship between
Mr.
Vanover and
Chairman,
American General
Mr.
Builders.
Chairman, I
Yeah.
object.
Now it
I
makes
object to
sense.
that. I object to that. I have no personal relationship with
Yeah,
any of the
which is why the
contractors.
city
I
won't provide.
spoke.
If they said they're gonna provide the
Mis-
cost, we will
All
see,
right,
and we'll handle that in a specific
I have
point.
already said that we're not gonna talk about cost here. We're not gonna talk about the contractor. But what we are going to address is the emergency situation here and whether the city needed to act on this and needed to act right away. And I'm pretty sure that not just what I see, but also, what Mr. Maskey said, and I'm sure Mr. Bradley will also chime in to say that it was definitely an emergency situation that needed to be addressed because of the possibility of somebody being injured, even taking out the electrical lines. So, there's no question to that I can see.
Mr. Chairman,
Yes.
if I may, because I was cut off, and I would like to respond. That our position is, well, I object to the statements made because I think they're just intentionally inflammatory without support. That
We provided
as
support
quickly
in the
as
document.
as quickly as administratively possible, we raised the building. But during that time, and I did express to Ms. Liverpool that we were going to be, today. She needed to send somebody today that could
And we did.
explain how they were going to maintain that, and she ignored that. She did not send somebody.
I did send
two
someone, and
additional-
you're
the-
stating the representative that I sent didn't give you specific information, and if you
He
don't have
claimed that
evidence
he
of
was
that,
unable
if
to,
you
Mr.
if
Chairman.
you don't have evidence of what went on in that conversation, I don't understand how that.
Mr. Chairman,
Mr. Chairman.
Yes.
Mr. Chairman, if I may interject, Attorney Ganglani here. If one party can speak at a time, Mr. Vanover is giving testimony right now, so if we could have that separated, please, thank you.
Yes.
So, Mr. Chairman, just a final statement, and we were not provided with a representative that could make those decisions, and that for the 2 days that it took to get the demolition moving, the appellant still did nothing. So we believe that you should uphold the violation notice is properly issued, and the emergency order as properly issued, because there's both state law and local law provides us to give instruction in emergency situations and then follow with the administrative orders and the administrative paperwork after the fact. And so therefore, we just ask that you uphold it. I don't believe there has not been any request for time. So we just ask that you uphold the notice and the order is properly issued.
I'm sorry, if I could ask just a few questions based on Mr. Vanover's statements.
Go ahead, Mr. Holm.
Thank you. What section of the Ohio Administrative Code allows you to just act and abate the nuisance with no notice to the homeowner? or
Mr.
property
Chairman,
owner?
Mr. Chairman, what I had stated in was one, I'm not the attorney here, but the Ohio Administrative Code allows us to act in an emergency without approval and permit. Right,
What section of the?
I believe your appellant or your your client, had brought up the fact that there wasn't a permit issued at the time as some red flag. But the Ohio Administrative Code, the Ohio Building Code, Chapter 1 allows for that.
Was it the Ohio Administrative Code or the Ohio Building Code?
Well, I don't know. They're the same. The Ohio Building Code is in the Ohio Administrative Code.
Okay, so why did the notice that you guys ultimately issued come under City of Cleveland ordinances and not under the Ohio Building Code or the OAC?
Mr. Jacobson, if I could get some support here, I don't think that I'm qualified to teach how legislation and law works to another attorney.
Through the chairman to Attorney Hall, this is Dan Jacobson, Department of Law. We are not required, through the chairman to Mr. Hall, Attorney Hall, we're not required to provide you the law that you need to follow. You're a licensed attorney, you have access to the same statutory laws that we have.
Okay, the question was, why did the city, issue a notice under the City of Cleveland ordinances and not under the Ohio Administrative Code, if you are now referencing the Ohio Administrative Code as support for your position?
Through the chairman to Attorney Hall, that's the way the city chooses to follow their law and their administrative processes are not before the board right now.
I'm sorry.
I'm not prepared to engage in a discussion right now before this board regarding those processes. If, however, after this hearing, if you'd like to contact me, we can engage in that conversation.
I will happily reach out to you, sir. What I would just point out, though, is the city has just identified that it acted under the Ohio Administrative Code, and the notices that were issued, none of them were issued under authority of the Ohio Administrative Code. So that, I believe, is a substantial failure to follow process.
And once you go read the laws, and you'll see how they're actually connected and reference each other, and speak to Mr. Jacobson. I don't want that statement to taint or to somehow influence the board. The reality is, do the work, and you'll find how they're connected.
That's not
one's reference to the other.
That is not the issue. The issue is due process and what was she entitled to notice of? What was she entitled to be on notice that the city was acting under? The issue is not how do these things work together. The issue is that they are saying they acted under the OAC and the OAC, but they did not give any notice under the OAC.
Mr. Chairman, Mr. Chairman,
yes.
The appellant claimed that not pulling a permit was proof of impropriety. Okay, the permit of inappropriate behavior, right? My statement was that as under the Ohio Building Code, in cases of emergency, work can be conducted prior to the permit. All of that, this has nothing to do with notice. He needs to, the appellant, in keeping their independent arguments straight, I was responding to why there was no permit issued at the time of the demolition. The law allows for it under the Ohio Administrative Code, which is referenced in the local code as what we use for permitting and plan approvals. Confusing, I think there's an attempt to intentionally confuse the service issue with this issue. And I just want the record to show that they are separate issues, and that I never stated that the order was issued under the Ohio Administrative Code. The permitting process and the approval process is codified under the Ohio Administrative Code, and therefore those provisions are allowed for.
They said your comment was the Ohio Administrative Code allows us to act and abate the nuisance.
That's not true. We can read it back.
That is what at least I wrote down while he was talking. So
okay, we can read that. We can read that back. That's not that's not what I said.
The board can review what specifically was said. My recollection, what I wrote down is that was exactly what he said. So the other question is, if the city was acting, well, your testimony is that the city was acting under its own ordinances as well as under the Ohio Administrative Code. Is that correct?
What I said was that the city was acting under our local ordinances and our local codified ordinances.
Okay.
And that portions of those reference, to the extent of the reference, the Ohio Administrative Code.
Okay, so the second question is, if your testimony is that the city had the right to act, before any notice was issued, before any permits were issued, before any permits were pulled, etc., why did the city issue a traditional notice that specifically informed the owner that they had a 30-day right to appeal?
Well, I can't answer Mr. Chairman, through the chair. Orders and permits and approvals are all separate things. So the question is asked takes from multiple portions.
I'm sorry, the question that was asked is not the question that was just answered. The question that was asked is, if she had no right to a 30-day right to appeal, why, which I believe is your testimony, why did the notice of violation that you issued tell her that she had a 30-day right to appeal?
Mr. Chairman, my testimony was never that she didn't have a right to appeal. She's here before appealing the notice. I believe that the fact that we are sitting here and having this conversation is proof that she had the right to appeal, and that therefore she also has the right to provide testimony, which she has done. The city has a right to refute that testimony, which we have done. I don't understand how, Mr. Chairman, how the counselor can say that she didn't have a right to appeal and yet here we are. I never said she never had a right to appeal.
Well, what you were
I
saying
think Brad
is,
is stating I didn't have a right to appeal before you tore Brad, and you can correct me, before the structure was torn down.
yes, absolutely.
Yeah.
It's I mean, in my opinion, it's totally clear. The notice of violation that was issued says 30 days, essentially 30 days to abate. And that issue,
that's not what, Mr. Chairman, I object. That's not what it says. The notice says that there's a 30-day right to appeal, and it does not say 30 days to abate. The abatement time is forthwith and immediate. It doesn't essentially say that. If that's how this counselor, this attorney interprets that law, then that's something that he can fight. But that's not essentially what it says. That's not the position of the city, and that's not the position of the case law that we use to support our work.
Okay,
well,
I'm hearing
you have
back
the
and
appeal
forth.
in front
Hold
of
on
you?
just a moment. Hold on.
Okay.
So I'm hearing a lot of, back and forth, and a lot of these little, I don't know if I'd call them innuendos, but a lot of the statements being made, are back and forth, and I believe they are things that can be argued, as far as, what was said, when it was said, all of that. I do know that when you have a situation and it is a hazard, an extreme hazard, as they were watching this wall move, then he was acting, I believe, within the time that he could to, and also giving some notice himself, but that he had to act to save the potential of a hazard to human life possibly, and also to knocking out wires to abate that violation. And I believe that that's something that we definitely had the right to do that, as I see it. And I will check with the board members if they agree with that. And so as far as what we're looking at, that's the issue that we're looking at here as the board, is that this city have the right to move in here and do this. And so then anything else that goes after that, I guess you would have to probably take it up with some other board or in court in order to rectify other situations that you feel may have been too pricey, maybe not notice enough, whatever you want to argue. But I think that for us as this board, and I'll ask the board members, Mr. Maskey, what do you see?
Can I respond to that before they do? What I think I hear Mr. Vanover saying is his position is we had the right to act and then we notify you and then you have 30 days to appeal to basically ask the board to decide the city didn't have justification for treating this as an emergency. So my question there would be, and my interpretation of the law would additionally be, what are you deciding? I mean, if you're deciding whether it was correct or not, I mean, I think there's got to be some testimony about the actual money, about what it actually cost, whether the bid that was ultimately granted was actually complied with. Because I don't think these things can be separated in the way that the city is arguing here.
Well,
Mr. Chairman, may I jump in?
who is this?
This is Robert Mash.
Oh, go ahead, Mr. Maskey.
I think this definitely, from what I see, and I concur with Mr. Vanover's earlier statement on what the building looks like and the integrity of the structure, from the front facade on the street to the back little building where the roof has shifted out of its normal form. And this, in fact, is a dire emergency. I'm actually surprised that we couldn't get the building down quicker based on the proximity to the street and the power lines. But with manpower these days, I understand these situations. Probably the cost of what the cost was is because it's an emergency and these companies have to remobilize at a premium to get somebody on site to do this. This isn't where you can get the best price and fit it in when it's someone's schedule. That wall is coming down. And even if the earlier photo that was shown from Google Earth some 8 months ago showed it plumb, and then all of a sudden it's pulling away, and then we heard testimony that the wind was making that flex, that could have been a major disaster. And we wouldn't be talking about costs. We'd be talking about death or damage, which is a whole nother discussion. So I concur that this was an emergency. It should have been resolved expeditiously. And the cost is for another discussion with another group. But I support what the city did, and I make a motion to uphold that.
There's a motion to uphold that the violation was properly issued.
Mr. Chairman, before you issue your ruling, law wants to again state its objection to any testimony given on behalf of costs. The board has heard sworn testimony that the emergency conditions did exist and that emergency action was needed. The board also heard sworn testimony that through phone calls and other means that the appellant knew of the emergency during real time, and that the city of Cleveland took emergency action as soon as administratively possible.
Yes, and
Mr. Gallagher, I hear you loud and clear that cost and those other things are for another court. And I know Brad, is saying, how can we discuss one without the cost? And if we're going to ignore the cost, we can take that up with another court, which we shall.
Mr. Chairman, there's a motion on the table.
That has nothing to do with this court. Obviously, you said this is the cost.
Right, and the problem is that we keep bringing it up.
Can I finish, Mr. Gallagher?
Okay, as long as you're not talking about this cost business.
No, we're not. I just want to make sure you understand. I agree with you that we'll save the cost for a different court. I hear you loud and clear that that's not, you guys don't have ability to control on that or rule on that. We'll take that up with the proper court.
Okay, so we do have the motion by Mr. Maskey that the violation was properly issued and the order to abate that emergency violation was properly issued. And there was no talk of any time or anything. So that'll be the motion. It was properly issued. Motion by Mr. Maskey. We have Mr. Bradley on.
Mr. Bradley. Hello?
We're talking about board member, Mr. Bradley, not talking about me.
Yeah, right, not you.
One
Yeah, it's
second,
board
please.
member. Yeah, she's gonna raise him. He has some problems sometimes with that
1 second.
Wi-Fi.
Mr. Gallagher, just another question, totally unrelated with Mr. Bradley. Is he just having mic issues and is he like actually hearing the hearing out? I just want to make sure for clarity because
We can
I
ask
saw
him. We can
Okay.
ask him.
Okay. Yeah,
Sometimes
I didn't know
it's
if
his
there was something
microphone.
we could, I didn't know if we could recall something to him just to make sure he heard
Well,
everything, because I know in the previous case.
yeah,
Uh,
usually he can. With his problem, a lot of times is with the mic
okay,
being heard. That's usually what the problem is.
yeah, okay. I just wanted to make sure.
Right. I understand. That's a good point.
He's there, Mr. Gallagher.
Okay. All right. So, can he respond?
Yeah.
We need a second to that motion. All right. So we got a second?
Second.
Yes?
Is there something we can ask him, like to
Yeah.
recall to make sure he heard the ruling?
Well, okay,
Oh.
so Mr.
Presentation.
Bradley, have you been listening to the conversation?
Yes.
Okay.
It's been cloud here real good.
Okay, you hear good. You're just having a problem responding. Correct? Okay.
Is there anything he can point out? I know he's saying he can hear fine. I'm just struggling with him seconding. Like, is there anything he can reference from our discussion?
Mr. Chairman, I don't know that it's appropriate to test the board members. If they
Right.
want to object to the proceedings, there's a venue for doing that too.
Okay, that's what we'll go on. So, Ms. Davis, there's been a motion by Mr. Maskey, second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Gallagher.
Yes. Okay, notification will be sent out within 2 weeks. Thank you.
Mr. Chairman, I do see Patrick Martin of docket A 12123 has entered the WebEx call. We did already hear his docket. It was denied and remanded. Do you wish to reopen this docket to give him opportunity to speak on behalf of his docket? This is
Okay.
Global United Holdings, Inc.
And I'm sorry, 7756 Broadway is dismissed. We can sign off, correct?
That is correct.
Yes.
Thank you. Thank you.
Okay, so A 12123 Global United Holdings, who is it that's coming on?
It is Patrick Martin.
Okay. All right.
So,
We're gonna reopen the case.
application and fees are in order. This is a condemnation of the main structure that was issued on May 11th of 2023. Appeal was received on June 11th, 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Would the appellant or his or her attorney or representative please state your name for the record?
Yeah, is that my cue? Patrick Martin.
Okay, Mr. Martin, you solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, let me, you recognize the property, Mr. Vanover, 1445 West 50th?
Yes, I do.
Okay, all right, go ahead, Mr. Martin, let us know what your plans are.
Yeah, we're currently working on architectural plans for an ADU in the back of the property. And in addition to that, we're in the process of developing exterior and interior upgrades to the main house in the front. We also have underway plans for a new driveway to the right of the property, along with landscaping in the front and backyard with a perimeter fence surrounding the back of the subject property. So those are the general plans for the property. We're actively working with our contractor on gathering all the information needed to get the city's approval for the ADU construction in the back. And then obviously once we submit that, we'll have that process underway. So
could you explain ADU to me, please? After demolition, is that?
It's a term that's used in some markets, but it's an additional dwelling unit. So essentially, it's a garage with a loft. Is what we're working on in terms of the drawings. We have the concept drawings already, and now we're working on the technical drawings.
Okay, now referencing two of the pictures there, you're showing where there was a structure demolished, but it was never, it's not abated totally. It's left with part of the foundation, I guess. Is that part of what you're going to be taking care of in the landscaping?
Yeah, we've taken care of. We had the foundation for the new dwelling, but the work that was requested to remove the additional pieces of the foundation from the previous dwelling, that work has been completed.
Okay, but I mean, when I'm looking at these pictures, have you updated that then from what I'm looking at? Or is this the current way that it looks today?
I have photos from when the work was completed about 2 months ago. And I can provide those photos. I can provide those photos to the committee.
How much time do you think you need here?
Well, drawings are submitted. I think that's going to be the part of the process that where we need to assess the lead time. Typically there's back and forth with respect to changes to the drawings or edits that the city typically wants. And then, of course, we make those adjustments, and then we go through the plan review process and then get those drawings approved. I would say that that's the critical path part of this process that we don't have. We just don't know how long that part's going to take, but once the plans are approved, we were given 90 days by our contractor to do the construction work.
Mr. Chairman,
I got a question. Yeah, for Mr. Maskey. Go ahead.
Yes, we've already remanded this to the city. It seems like the appellant is a little bit unclear and we're running late in the day. I think he still has the ability to keep doing what he's doing. And by us remanding this project to the city, it means he'll have to work closer with the city to get these approved and get this resolved, which is probably beneficial for him and for the city and his neighbors. So I am not opposed to changing my vote. So I suggest we keep it remand to the city.
Okay. So you've heard Mr. Martin, what Mr. Maskey has said. I kind of agree with him. We've already remanded this, and I think there's a lot to it, to what you got going on. And you can, as quickly as you can, get your information into the city for what your plans are, for your drawings, whatever you need to do, get it into them, and you can just proceed on. Because there's so many unknowns, I think the remand is is good. So I'm going to go over to Mr. Vanover and see what he has to say.
Mr. Chairman, I agree that I think that it's been remanded. I mean, he claims that he satisfied the requirements of the notice, so there's no need to do anything more. The new project is the new project. It will get reviewed on its own. So we ask that you remand it, keep it remanded, and allow us for further action by the department.
Okay. So so I would say we don't have to take any action because
Not to take any.
it's remanded. And so that's what we're going to do. So just to let you know, you'll be getting a notice within 2 weeks that it is being remanded, and you can keep proceeding on. Okay, Mr. Martin?
Thank you.
All right. Thank you.
All right. Thank you. Thank you, sir.
Yep. Okay, so I think we're through with the cases, I believe. Is that correct, Ms. Davis? I think we're done.
Yes, we are done.
Okay. All right. So approval of resolutions. A 6823, A 7023, 7123, 7323, A 7423. Motion?
So moved.
Second. Okay, motion by Mr. Maskey, second by Mr. Bradley.
Mr. Bradley?
Yes.
Mr. Maschke?
Yes.
Mr. Gallagher?
Yes. Approval of minutes for September 13, 2023. Any additions or corrections?
No.
Motion?
So moved.
Moved by Mr. Maskey, second by Mr. Bradley.
Mr. Bradley?
Yes.
Mr. Maschke?
Yes.
Mr. Gallagher?
Yes. Is there anything else to come before us?
No.
Good. We stand adjourned. Thank you, everybody.
All right. In 2 weeks.
2 weeks.
Okay.